tenant is possessing the place, and while the landlord is the owner. The possession is de facto. That means it is actual, while the ownership is de jure. That is as per law. Possession as per Indian law is 9 out of 10. So one who has possessions is treated as to be having 90% of the things in his control. A possessor cannot be dispossessed without following due procedure of law. So when this possession is adverse to the owner or against the owner, then it is called adverse possession. While ownership is de jure, that means as per law, which denotes the relationship between a person and his rights vested in the property. Possession is a good title against anyone who cannot show a better title than the possessor. So adverse possessor, as per there is no definition given or no statute prescribes the definition of adverse possession. It is based on the law developed by the courts. Actually, it is a common law concept, which is this concept of adverse possession appeared in the Code of Hammurabi, which is approximately 2000 years before Christ era. So it's not that it's very new law, it's acknowledged in the whole world. Various countries accept this concept of adverse possession. What differs is only time of this limitation period. Like in India, it's 12 years. In UK, it's 20 years. And in ancient Roman law, it was 3 years. So the period for this is prescribed under law of limitation, which is Article 12, this Article 65 is 12 years. 12 years from the date when the possessor declares that his possession is hostile to the true owner. It's not that a person who is holding a property silently for many years, he comes suddenly and declares that he is in adverse possession. No. A mere holding of a property for a long period does not confer title of adverse possession. There are certain ingredients which I will tell you. Law of limitation does not define the concept of adverse possession, as I informed you. This Article 27 is in negative covenants. It is the only article which is in negative language, which states that if a person does not come to the court within a time specified as under Article 64 and 65 of the Limitation Act, his right extinguishes. That means after that period, he cannot claim his right. So the concept of adverse possession has a root in the aspect that it awards ownership of land to the person who actually holds it or ripens benefits from the land, so that land should not be kept idle and take benefits from the land for the benefit of the society. The benefit from the land being held adversely, but it allows a specific period to the true owner to claim his title back. So even if in that period, the owner does not go to the court for claiming his right extinguishes. Thereafter, he cannot claim his right. So law of adverse possession is governed basically as per Article 27, Article 64 and 65 of the Limitation Act. There is one more, this specific relief act, section 5 and 6 is there, whereby if a person is dispossessed from a property, he can go to the court for claiming his uh, possession or repossession. And as per section 6 of the specific relief act, once a person goes, actually it is a summary procedure. So he can get an immediate relief from the court. And when a person moves before the court under specific relief act, under section 5 and 6 as the case may be, in that case, and the courts declines the relief, in that case there is no appeal lies. In that case he can go as per civil procedure code. There is no restriction on that. So what are the ingredients for adverse possession? These are that property which is must, which belongs to other person, not to the person who is in control or is in possession of that property. So what should be nature of possession of property? Possession must be actual, peaceful, and lawful. The person should not be a trespasser. It should be visible and exclusive to the true owner. That means public or neighbor must be aware that a person is having possession of the land and is staying over there with their family, cultivating the land, or has developed the land, constructed some house over there, or redeveloped. It should be continuous and uninterrupted. It should be notorious, hostile, and adverse to the owner. And this hostility should be known to the true owner. It's not that a person who is in permissive possession, to whom owner has granted permission to stay on in a property, he should suddenly comes to the court or to the owner that he is in adverse possession. It is not so. So, and the another factor which is sine qua non and must is that his intention that he wants to ouster the owner. If there is no intention and he wants that he will leave at any time whenever the owner will request him or will suggest him, in that case, this is not a case of adverse possession. So this animus possidendi that he thinks or he intend to ouster the owner, it must be in notice and knowledge of the owner. If there are circumstances that showing that open and notorious act of taking possession, knowledge may be presumed. So if a person develops or puts a fencing and the owner has no objection, in that case it will be treated that it was an implied knowledge. Where the assertion of right is secret and not open, the possession cannot be held to be adverse. And there should be dispossession of the true owner. It's not that owner is coming over and staying over there. There should be dispossession of the owner by the possessor. Now, what is not adverse possession? As I told you, a permissive possession or permissive entry is not an adverse possession. Like co-owners cannot be said to be in adverse possession for each other, although there are certain exemptions. If a co-owner claims his title on the basis of adverse possession, in that case he is required to prove all the ingredients and elements for adverse possession. And there is a judgment of Honorable Supreme Court, that is 1995 for SCC 496, whereby Supreme Court held that unless ingredients of adverse possession are met, one cannot be said to be in adverse possession. The possession of trespasser is not adverse, nor long possession is synonym with adverse possession. properties which are reserved or dedicated to public cause, like government properties for school, hospitals, and any other noble cause for public, that cannot fall under this term of adverse possession. A person who is staying over there or possessing or holding that property, there is no limitation period prescribed. Basically, this concept of adverse possession will not apply in those cases. So a person who is having possession over government land and it's not a rehabilitation area, in that case, this concept of adverse possession will not come into force. He will have to vacate at any point of time whenever government comes to get him evicted. So when this period of limitation will start for claiming adverse possession, this will start from the period when the possessor has declared his hostility to the owner. If a person is in possession which is permissive, or it's secretly planning something, it won't be treated as that he was in adverse possession. So there is a judgment. It's Annakali versus A. Vedyanagam. It is 2007, 14 SCC 308, whereby Honorable Supreme Court observed that while filing a claim for adverse possession, two elements are required. One is the possession of the defendant should become adverse to the plaintiff, and the defendant must continue to remain in possession for a period of 12 years thereafter. So once he has known his hostility to the owner, only thereafter this 12 years period will commence. So within this 12 years, if owner does not go to the court or invokes his right as prescribed under Article 27 of the Limitation Act, in that case, his right extinguishes and the possessor can file his suit based on adverse possession, claiming his title and suit for declaration that he should be declared as owner as he was in adverse possession of the property for more than 12 years. So what should be averment for adverse possession? These are, one judgment is 2007 6 SCC 59. This is PT Munichekkana Reddy versus Rivamma. These averments should be of twofold. One, to recognize the title of the owner. It's not that one is coming for adverse possession by saying that the owner has no title. No, that won't work. He should admit the ownership of the true real owner against whom he is claiming adverse possession. Another is to enjoy the property adverse to the title. That means animus possidendi, which is known to the owner. So this is must. The three classic requirements as per law, which are required to be proved by the person who is going to the court based on his possession, on his adverse possession, these are discussed in three cases. These are Balakrishna versus Satyaprakash 2001, 2 SCC 498. They referred one earlier judgment, which is 1964, AIR 1964, Supreme Court 1254. This is SM Karim versus Bibi Sakina. So what Supreme Court observed that there are three classic requirements which are required to be fulfilled. This is in legal terms is NEC V, NECVI. Then second is NEC clam, NECCLAM, NEC clam. Third is NEC precaria, NEC Precaria, which means possession should be peaceful, open, and continuous. There should not be any discontinuity in possession. The judgments were followed in Karnataka Waqf Board, which is 2004 10 SCC 779. I am repeating. This is Karnataka Waqf Board 2004 10 SCC 779, wherein Honorable Supreme Court held that possession must be adequate in continuity, in publicity, and in extent to show that their possession is adverse to the true owner. It must start with the wrongful dispossession of the rightful owner and be actual, visible, exclusive, hostile, and continued over the statutory period. If there is the possession discontinues, in that case, he cannot take plea of adverse possession. So physical fact of exclusive possession and the animus possidendi to hold as owner in exclusion to the actual owner are the most important factors. Plea of adverse possession is not a pure question of law. It's a mixed question of fact as well as law, because that his possession was in continuity, peaceful, open, hostile, notorious, and it was public. It was not a secret. Therefore, a person who claims adverse possession must claim and must in his pleadings that on what date he came into possession, what was the nature of his possession, whether the factum of possession was known to the other party, how long his possession continued, and his possession was open and undisturbed. So these are the 5 requirements or issues, we can say, which are required to be proved by a person who is coming to court based on and demanding relief on the basis of adverse possession. Now there is a judgment is 2007 3 SCC 569, whereby Honorable Supreme Court held that communication of hostility to the real owner is must. If it is not there, or if real owner is not aware or it was secret, so it cannot be said that adverse possession is there. He has to show his hostile title and it was made known to the real owner. The next is Lallu Yashwant Singh versus Rao Jagdish Singh. It's AIR 1968-620, which says forcible possession is illegal. So if one wants to dispossess the other, he should go to the court and take proper action as per law. Now, next judgment is P. Lakshmi Reddy versus L. Lakshmi Reddy, which is AIR 1957 SC314. As per this, possession should be in continuous. Any breaking of possession will wipe out plea of adverse possession. Then now comes Article 64 and 65. Based on it, a question arose whether because in starting, the plea of adverse possession was treated as to be a defense and not as a plea as a plaintiff should come to the court and claiming his title based on adverse possession. So earlier it was taken that it can be this plea of adverse possession can be raised as a defense and one cannot claim title based on adverse possession. So there are judgments, many judgments by the Honorable Supreme Court which held that Articles 64 and 65 of Limitation Act nowhere restrains any person coming to the court claiming his title based on adverse possession. So if any person can file a suit claiming that he is entitled for declaration and title based on adverse possession. There are few judgments which I am going to refer. These are 2007 9 SCC 641, Deshraj and others versus Bhagat Ram. Then Kshitij Chandra Bose versus Commissioner of Ranchi. For government land, this limitation period is about 30 years, not 12 years as of in private lands. This Kshitij Chandra Bose's citation is 1981, 1 SCC 103, which is by 3 judges bench. One more judgment is there. This is Nayan Services Society Limited versus KC Alexander. This is AIR 1968 SC 1165. In case where Supreme Court observed that in case the rightful owner does not come forward within the period of limitation, his right is lost and the possessory owner requires an absolute title. Then a recent judgments last year came. This is Ravinder Kaur Grewal versus Manjeet Kaur. This is 2019 8 SCC 729, whereby Honorable Supreme Court held once a right of the true owner is extinguished, another person acquires prescriptive right by re-entry of by the owner or by acknowledgement. And very interesting thing which has been observed is that this adverse possession is a heritable right. So a generation can stay over there, generation to generation. It can be admitted and it will be a lawful title. So this was my views on adverse possession. If anyone wants to ask any question based on this, they can ask.
Vandana, there is one question from Karunakaranji. If you can read in chat box. In case of ancestral property in the joint names of family members and allowed to one or two of the family members to take care of the property, can the caretakers of the property claim their ownership?
Caretaker? No, it depends on whether they have showed that they're in possession as a hostile owner. If they have not shown this fact to the owners, they cannot claim. So they will have to show when they have declared themselves to be in adverse possession.
Okay. Any more questions?
So the period of 12 years starts from the day when they say or when they inform to the owner or when they do anything which by which it can be presumed that they are going to claim through adverse possession.
There are no more questions, but I would like to tell you, can you enlighten a little bit on agricultural land, something on adverse possession?
No, agricultural land, adverse possession, there is no differences made on agricultural land or residential land or private land. But for government land, rule is different. For government land, period extends from 12 to 30 years. And if a land is reserved for public utility, then no one can claim based on adverse possession. And there is no limitation for that.
Nikita is asking,